The
Cast.
broadcast is now starting. All attendees are in listen-only mode.
Well, hello, everybody. My name is David Gross with Condé Systems, and we're honored that you're part of this extremely useful and interesting webinar. I've got to admit, Jimmy, I don't think I've ever been part of one that wasn't really focused, if you will, on sublimation decorating or decorating in general. So this will be interesting. Our guest host, of course, today is Jimmy Lamb with Sawgrass. And I guess today you are representing Sawgrass, but you're probably more representing just your wealth of experience. And we'll call that experience to some extent the experience of hard knocks.
Yeah, and David, I do want to clarify that I don't really want to say I'm representing Sawgrass on these issues. I obviously do work for Sawgrass, and my job is education, but everything I'm sharing today is from my personal experience, just as you said. And so what I'm going to be sharing is just things I've been through, generalized information. I'm not an attorney. I don't have any legal experience other than being on both sides of the law with this particular issue here today. So I don't want there to be any thoughts of
No confusion. And you don't
no
play an
confusion.
attorney on TV. So,
No, I don't play an attorney
yeah.
on TV or on the stage or on a webinar. So I always want to be
So
clear on
very,
that.
very
So
clear. We're giving you, I guess, just a little bit of our knowledge base, but in no way, shape, form is it intended to be information you should act on.
right,
If you need legal help, you should respond. You should contact a competent attorney. And I have had the experience of working with many attorneys, and some are just not competent. So if you ask an attorney for help in a particular area, they may say yes, but have no experience in that area.
true,
So,
very true.
so please be careful. You are in listen only mode, and during the webinar, which will be recorded, you can post questions. If Jimmy can get to those questions at that point, great. If he can't, we'll try to handle them at the end. There may be some questions that we'll try to handle offline, but ultimately, this webinar maybe will open your eyes to maybe some questions you should ask that you're not even aware. So maybe we don't answer any questions per se, Jimmy, in this webinar, but we certainly get the wheels turning so that our clients can be better educated and stay out of trouble, prepare for the future,
Right,
and also to protect their own intellectual property.
right.
With that, Jimmy, I'll let you say the disclaimer. How about do it one more time?
Okay. Well, um, we are going to get started here, but first, I'd like to ask a few questions. David, I have a couple of polling questions for the audience, so we can just kind of get an idea of who's there, and then we'll cruise on from there. So, if you've been with us in the past few, I've done this, and it's totally voluntary. But my first question is: are you currently producing sublimation in house? I always like to know who out there is already in business, who's thinking about getting into business. So. Two answers there. If you wouldn't mind just chiming in, I would appreciate that. Again, it's totally voluntary, and I'll show you the response. But I can tell you so far, the majority of you are already in business. So we're going to give this about 85% of you have voted. We'll give it just another couple of seconds, and then I'll show you guys the results. And then I have two more questions for you. We'll make it quick and then straight on into the right information for you. Okay, I'm going to close that one, and just to show you, 84% of you in business, 16% not, or at least not producing sublimation. You could actually be in business doing something else. We understand that. Okay, so next question is, since most of you are already in the sublimation business, I always like to know what type of equipment you're using. It does not matter, okay, for our purposes. There is no requirement that you're using a Sawgrass system. Or a Rico or anything. It's just, again, it's always interesting to kind of see what people are using out there. So we have a few choices there. If you wouldn't mind clicking off on your screen, and I'm watching here as the answers come in. And I see about 75% of you so far. And we'll give it just a few more seconds and then go on to the final question, probably the most important question of all. So, okay, well, I appreciate that. I'm going to go ahead and close this one out, show you the responses. And you can see 74% of you using an SG400, SG800, 13% Rico, 9% Epson, and 4% other. Okay, the final question. This one, very important, has everything to do with what we're getting ready to do here today. And it is, have you ever had to deal with copyright and or trademark issues? At first I was going to say, have you ever been in legal trouble? And I decided that just didn't sound good. You don't have to be in legal trouble to have to be able to deal with these things. I mean, unfortunately, a lot of times it's when some legalities come up that we first become aware. But reality is a lot of us innocently make mistakes and we end up getting a letter. So about 85% have voted. I'm going to go ahead and close this one out. Appreciate everybody participating. This is our final question. Here's what the answers look like. And I see that 60% of you have not had to deal with questions. 40% yes. So that's a lot of people who've come across this. I've been in this business
Not
a
as
long
many
time.
as I would have thought.
I know.
I would have thought that just about everybody would have been involved, but I certainly understand that one.
Yep. So thank you everyone for that. So let's get started. So the very first thing we need to do is we need to read the disclaimer. And if you have a small screen, you can't read it. Why did I do that? Because so many of us don't read the small print. And when we get a little deeper into our discussion, we'll talk about things like licensing, buying stock designs online, things like that. This is my disclaimer, okay, which is the same thing we've been telling you. And that is, I'm not qualified to teach the class, and I don't think David is either. So therefore, we're off the hook. See how that works? As I like to say, anything I say cannot be used against me in a court of law, because I've already told you I'm not an attorney, okay? But my other point is always read the small print, all right? So one last time, as David said before, always consult with a qualified attorney if you have a question that you needs a true interpretation, okay? Typically, you want to find an attorney who specializes in copyrights and trademarks, and they are referred to in many cases as an IP attorney. IP stands for intellectual property. Okay, as David said, you want a competent attorney. You don't want a divorce lawyer. You really don't want a contracts lawyer. You want an IP attorney. Okay, I will tell you that copyright and trademark law is very gray. There's a lot of gray areas, and therefore you need really good legal representation if you have to go down that path. Okay, but I've been there, done that on both sides, so therefore I'm considered to be a little knowledgeable about what can happen. Okay. All right, so because we're in the business of reproducing artwork and logos and images, copyrights and trademarks become serious business for us. One thing I do on the side is I sell stock designs. So that means I have to protect my intellectual property. But I've also been where I'm reproducing, images where I have to worry about, did I do this right or wrong? Or did the person come to me who implied they had the rights for me to reproduce something for them when they did not? So we have to think about all these things, okay? And we have to understand the difference between a copyright and a trademark, which I'm going to show you too. So we're going to start with copyrights as our very first approach. As I said, it's intellectual property, IP. Keep that one in mind. That's very important when you see those two letters, okay? It refers to legal property rights over creations that come from the mind, okay? Examples include inventions, which a lot of times fall under patents, okay? Literary and artistic works, that's usually us, the artistic kind. Symbols, names, images, and designs used in commerce, that's all intellectual property, and copyright's part of intellectual property. So just again, intellectual property is like a big umbrella with these kind of things that people create with their mind, but copyrights is part of that, okay? And copyrights tends to be artistic and literary works, okay, as much as anything. A lot of times symbols are copyrighted, sometimes they're not. Just to give you an example of what I mean by that, if you look at the Nike logo, which is a swoosh, they have a copyright on the swoosh, but they also have a trademark on it because it's representative of Nike. So that's where the trademark comes in. And the copyright is the actual image itself because someone created that unique look, right? Something to that effect. That's how that works, okay? You can do a lot of learning on your own. I know most people don't read government websites that deal with legalities, right? But if you go to copyright.gov, there's a lot of good information there. It's not that hard to read, okay? You can actually understand a lot of what you read. You may not be able to make good legal decisions, but you could at least try to understand what copyrights are all about. So I do recommend everybody at some point, you use that as a reading assignment. Just every now and then go look at it. Don't try and read the whole thing in one sitting, okay? You can pick up some information there. The Copyright Act of 1976 is the governing doctrine for U.S. copyright law, and our copyright law is honored by some other countries, but not all countries, okay? So just because you got it copyrighted here doesn't mean somebody in another country cannot rip you off, and there's not much you can do to them unless you get them back in this country. So that's important to understand. So let's just do some scenarios, okay? Because as I go through a few scenarios that we've probably all run into, it's an easy way to start explaining. So what I'm going to do is I'm going to give you a scenario, and then I'm going to go back and tell you a little about how copyright affects that scenario. So very first one, you go to the internet and you download a cute Mickey Mouse design. You sublimate it on your kids' clothes. Nothing was sold, and you didn't earn any money for the project. Is this okay? And a lot of people think it's okay because you didn't sell anything, okay? But we'll get back to that one in just a minute. So scenario number 2, the Super Bowl is coming up, and of course that's my team, and they weren't in the Super Bowl last year. But anyway, and you decided to create some sublimated shirts for friends with your favorite NFL team's logo as a fun gift at your Super Bowl party. Is it legal? Seems innocent enough. All right, so let's talk about the law. If you actually go and read section 106 of the Copyright Act, see, it sounds like I'm a lawyer, right? That's just because I read it before. It says that in general, that's a specific term, isn't it? That section gives the owner of copyright the exclusive right to do and to authorize others to reproduce derivative works. I'll explain that in a minute. Distribute, copy, display, etc. Okay, now this is what that means to me. That whoever created it has total rights to it. And I'll be the first to tell you there's some exceptions to that in the copyright law. But in general, that's what it says. That's the wording. I took the wording out of the law and shared it with you. So kind of reading and understanding is important, but we also understand that it isn't always as black and white as we want it to be, okay? But this is the very basis. The author has exclusive rights to do and to authorize others to reproduce, okay? Now, let's go back and look at what we were talking about. There's that Mickey Mouse again. You know, a lot of people out there, they'll look at the Mickey Mouse and say, yeah, I'm probably not supposed to use that. So I'm just going to change it by 20% and then say it's mine. And that has led to what's been known as the 20% rule. It's also been called the 25% rule and the 30% rule. I've heard those too. And that's all fiction. Okay. According to my attorney, that's fiction. He actually explained it to me. And I'm going to explain it to you here in just a second. But if you think that you change it by 20% and claim it as your own, it's now not an exact copy of the original, so you're free to use it, right? You know, like you see right here. The answer really becomes maybe as much as anything. So let me explain to you something called a derivative work. A derivative work is something, in this case, we'll use the 2 Mickey Mouses. You have the original, and then somebody created or derived another version, which was that funny looking Mickey Mouse, right? And so a derivative is based on something else that's original. And the thing is, if you read the first part of copyright law, it says that the author of the original work has exclusive rights to authorize preparation of or any kind of reproductions. Okay, so if you didn't have permission from the original author to take their design and alter it, which you would be doing, then you're kind of violating it anyway. All right. But there's actually a section written specifically on derivatives because it has many different effects out there. Now, it gets confusing to people sometimes, and sometimes I use music as an example. So Paul McCartney writes a song. All right, we all know who Paul McCartney is. And then the Boston Pops orchestra wants to reproduce that song with their own arrangement. Okay, so the orchestra is going to play their own arrangement of Paul McCartney's song, and maybe you're going to hear it in the elevator somewhere, right? They have to go to Paul McCartney and ask his permission. Hey, can I take this song that you wrote and do a new arrangement? And Paul McCartney either says yes or no. If he says yes, they can do it, and there's probably a contract and money and all that other stuff. So now the Boston Pops guy goes and writes his own new arrangement of Paul's song. What's interesting is this new arrangement, because it came from the composer's mind, even though it was based on Paul McCartney's song, it came from his mind. It is a new original work, okay, and it has its own copyright. So that arrangement actually has a copyright separate from the copyright that Paul McCartney has on the original. Are you confused yet? So now it gets to be more fun because even though the Boston Pops composer has a new version with his own copyright, he still can't produce it without permission from Paul, who's had the original, because his work's a derivative. And Paul McCartney controls the derivative, though he himself does not have rights to the copyright on the derivative. He has to go to that composer to get permission to play that version. So, I mean, that's how copyrights kind of work out here, man. There's a lot of things going back and forth. Bottom line is, if you change something that belongs to someone else by 20% and try to call it as your own, it probably won't pass. Now, that is up to the courts to decide. And in many cases, maybe you created something yourself from scratch, and it just so happens it's very similar to something someone else had created from scratch. You didn't actually take theirs and change it. You just created it one day. That again would be decided by the courts if yours is too close to the other person's, and then of course who created it first. So that's why we tend to document things with copyright law. Another scenario you need to be aware of, and it's called works made for hire. And I think actually I have some slides on it in just a minute. But if you pay someone to create something for you, you may or may not own it depending on the wording of the contract, okay? Because typically the artist who created it, it belongs to him or her unless they give up rights in a written contract to you after you paid them. So we'll touch on that in a minute. There's a lot to know in there, David.
Yeah, and let me just reiterate, you can take a breath. If you hire somebody to do web work for you, you really need a contract or agreement letter or something that says that you own the work they're producing. Otherwise, in a dispute, just like Jimmy said, the courts will say that you do not own the work. And I know that doesn't rub people the correct way, but it is nonetheless true. So if you have a 1099 employee, you need to have a agreement with them that their work is owned by you.
Right. Now, if you have a full-time employee on your staff, not a 1099, and it's spelled out in their job description that their job is, say, to create, great new works of art for, Condé customers, and they work for you, because you're covered in their job description as a full-time employee, then, that means that you as the employer are actually having, the ownership. But just like you said, if it's a 1099, totally different story. you know. So you have to definitely protect yourself with that. And be careful. You may go to an ad agency and pay them to create a logo for one of your clients. So does the client own the logo, or does the ad agency own the logo? How is it worded? You got to look into that. I'm going to give you a little example visually. I'm also in the embroidery world, and I do what we call embroidery digitizing. And this comes up all the time because people bring us artwork, and then they want us to be able to create a stitch pattern to sew it. So what happens is the artwork, like if David brought me the artwork and say, hey, Jimmy, this is my boat. I want you to create an embroidery file for me. Okay. Well, he brings me the artwork, and it's his artwork. Okay, it belonged to him. You know, he brings it to me, and then I use my brain to figure out the stitch pattern and maybe, you know, some creativity, because I like stitches going one way and another digitizer likes them angled a different way or whatever. But at the end of the day, unless we have a signed contract that says he owns the stitch file that I created, he doesn't own it. I own it. Okay. And, you know, in the embroidery world, this comes up a lot. Sublimation world, we don't see it so much, but we do see that in the embroidery world. If a person creates a stitch file, that stitch file is a derivative version. It is protected by copyright, but I could not use it without David's permission, but he couldn't use it without my permission. So I love the way those things work, right? Oh, well. All right, so yeah, we covered that one here. We'll just move on to the next one. And this is the same thing. You create an image for a customer to use based on his requirements. You charge him or her a fee for your work. They ask for a copy to use elsewhere. Can you refuse? Depended on what the contract said. Okay. Who really owns this design? And that's when we go into the works made for hire. If you have a document or an instrument, I think the legal people call it an instrument, that says that what you are making this new piece of artwork or this creation for someone, and they are paying you to make it so that they will own it, and that you're agreeing to turn over the ownership to them, and you both sign the contract, that's a works made for hire, and it does change hands. You don't have such contract, it's still, you know, it's still the person who created it pretty much stays in their ownership. So it's important to have contracts. Anytime you have anybody do any artwork for you, anything custom like that for you, make sure you have a contract that spells out it's yours. Same thing with photographers. Just because a photographer takes, you know, pictures of your wedding doesn't mean that you have unlimited rights to all those photographs. Most photographers don't sign the copyrights over to the photos. They just, you pay them a fee and they give you the photos that you purchase. But actually in a lot of the small print, especially with corporate photographers doing stuff for ads and whatever, there's a limit of how many times you can reproduce those photos. Something to be aware of. Okay. This one's really important. This is going to apply to every one of us every day. Okay. You buy some stock designs online, but you end up not using them very often. Another product decorator or sublimator or whomever wants to trade some of their unused designs for some of yours. Is it okay? I mean, you bought the things, you should be able to trade them, right? Well, this was when we start talking into what we call licensing. And again, remember, the person who created it has total rights to it and how it's used. It's very important for you to always read the small print. If you go to some of these companies online, there's lots of great reputable companies, okay? When you purchase that stock design, you do not own the design. You are purchasing a license to reproduce the design and then put it on things like coffee mugs and sell the mugs, which is okay. But at no point can you sell the physical design itself, the file, the design file. You cannot trade it, you cannot give it away, and you cannot sell it because you never own it. Okay, you only own a license to reproduce it. Very important. That's why I said at the very beginning, read the small print, because everybody has a licensing agreement that sells images. Make sure you read that for the free images too. A lot of people go looking for those free images online. Be very careful with those, because you want to, first of all, make sure you understand the restrictions. A lot of times you cannot use them for commercial purposes. And I'm also going to tell you, okay, I don't want to step on any toes, There's a lot of people out there giving away free designs they don't have the right to give out, and they're just trying to lure you to their website.
That's absolutely true. And if you read the fine print, ultimately it'll say is that you're on your own when you use these, that they are they're claiming no liability regarding the copyright of the image. Not a good thing.
No, because it can come back to haunt you, and I'll show you just how much it can cost you in a second. This one I've heard pop up more than once, and let's say you buy a collection of designs for your retail store. So we're really talking about brick and mortar store, okay? Physical location. Later you open a second location, you're going to make a copy of the designs for the new store. Can you do this? Well, here we go again. It depends on what the licensing agreement says. I can tell you in general terms, most licenses allow you to have one working copy and one backup copy per location. If that's the case, if you open a second location, you have to buy another copy. Okay, read the small print, and if you don't know, pick up the phone and call them. A lot of the really good reputable companies do work with undercover people who go around looking for violations, and will come and pose as a customer and look at what a shop is offering, and then go back and verify that shop actually has the rights to those designs. And I've seen a lot of that. I've been in this business a long time and seen a lot of that out there.
And unfortunately, if you call and ask, you might get one answer that is, and so it would be a wise thing that if it's a complex question or something you don't understand, get it in writing.
Yes, very, very good point. What does it cost if you get into trouble? Well, and again, this is right out of the copyright law, but there's so many gray areas on all of this. Okay, just keep that in mind. But the point is, you can be held liable, and it can get crazy, because as you see right here, not less than 750 or more than 30,000 as the court considers just. However, that didn't mean in total. That means per incident. And I did have an incident. I'm not going to get too deep in it, there's no need to, but let's just say that I had a business relationship with a very, very large corporation who is reproducing or having me reproduce my images, because I agreed to allow them to use them in their retail product line. And I did all the work, and at some point they were able to get their hands on some of my files, and then we parted ways, and the next thing I knew, someone else was reproducing my images for that company. And when I talked to my attorney, he said, well, you know what, you could get as much as, okay, he didn't say you would, 30,000 per incident. I said, well, I realized that because I was producing 15 to 20,000 shirts a year with this, that's 15 to 20,000 infringements. And he said, absolutely right. Every time it was placed on another product, what's an infringement? I said, dude, that's a lot of money, And he says, dude, it's going to take you a lot of money to ever collect it too, So, I mean, it was, it's not that simple, right? But the point is, it could be really expensive, and you don't want to find yourself on the wrong end of the stick. I will also say, because I have been on the wrong end of the stick, that most reputable companies, if they feel like you're violating their copyright, will send you what's called a cease and desist letter. And the letter will say, oh, well, this is what you did wrong. Okay, don't do it again. That doesn't mean that they have to send you a cease and desist. They could just go out and sue you. But most realize it's a lot of money to sue you. And, and a lot of times they look at you and say, hey, you don't have enough money for me to sue. You know what I mean? My attorney said, listen, if I was going to sue somebody, you need to give me 10,000 right now as a retainer. Expect it to cost anywhere to 40 to 50,000 before we even get to court, and that it may take 5 years plus and hundreds of thousands in the long term, and you may not win. And I'm like, ooh. So, we did the cease and desist routine instead of really going after them. But yeah, there's a lot to know. And if you ever get a cease and desist and you feel nervous about it, go find an attorney, because there's also some very disreputable people. And I can't name them, but and they're not anybody you might have heard of either. But I know of a couple of companies out there who routinely flood stock designs onto the internet, and then they go find people using them and turn around and want to sue them. And interesting enough, usually the amount of damage they want is about $8,000, because most attorneys would tell you that they will cost more to hire them as an attorney than it would be to pay that. I mean, that's really dirty stuff. Okay. So I just want you to be aware. These are things I've run across, and you want to just protect yourself. I get more questions too all the time when I do this about how to get around the law, and that's not what I'm in the business of doing. If you want to get around the law, go see an attorney. So just keep that in mind. A couple of extra things on copyright. As soon as you create it, okay, it belongs to you. You don't have to register it for it to belong to you, but the reason you register it is to prove it. Okay, if it's not registered, there's no way to prove that you created it and when you created it. And what I actually did with my attorney is he set up the first few copyrights for me, and I paid his fees, and then he showed me how to do it, and I just started doing my own after that. And the cost for basic registration starts at $35. That was a year ago. It could have gone up. Okay. And in general, it has a lifespan extending up to 70 years past the death of the author. But some of these have been renewed. Disney's been very vigilant on keeping theirs renewed. Walt Disney passed away a long time ago. I don't think it was 70 years ago, though. But I mean, they worked very hard on trying to keep those things going. And then there's some things out there that that are hard to even figure out who has the copyright to. Who has the copyright to the Mona Lisa? Da Vinci's been gone a long time. So I don't know. I don't know the answer to that. So please don't ever ask me that one. Ask it to an attorney. I don't know. I mean, some things have lost their copyright, over time and just become public domain. Again, I can't answer that for you. Those are things you talk to an attorney about. Okay. One other thing, I like to share real stories, just so you know the things you run into. One day I had a gentleman come in, and he had a box of children's t-shirts and shorts, and he had with him a copy of what was obviously a Disney design. I think it was Donald Duck. It's been a long time, and he wanted me to put that on there, and I said, well, I can't do that. That's a copyright violation. And then he said, and my next response was, do you work for Disney? Are you a representative of Disney? Can you provide me a letter from Disney with authorization to do this? A verified, letter, et cetera, et cetera. And he said, no. He said, you don't understand the law. Love that. And he said, and these are just generalized numbers. Okay. It's been a long time. I don't remember the exact numbers. He said basically something like, if there's not more than $2,000 worth of merchandise, it's not illegal. And I said, I don't believe that, and I'm not touching it. Later, I read an article, again, I don't remember the exact number, so you can't ever quote me on this, but it was something to the effect that if you didn't have more than a certain amount of dollar amount, that you had reproduced illegally, it wasn't a felony. It was just a misdemeanor. Okay, well, they can still sue you and take your whole business away. So, yeah, the guy, he was right. I didn't know the law, but neither did he. So, the reality, I use a phrase, David, that I learned in marching band in high school. I wasn't the best musician, played trombone, and we had some really good trombone players. And the band director used to tell me, Jimmy, when in doubt, lay out, meaning if you can't hit that note, don't do it, because someone else can do it for you. And that's how I treat copyrights and trademarks, is when in doubt, lay out. When I see something that I think could get me into trouble, I immediately ask them for a certified letter of permission to reproduce this. And then I file that away should something go wrong in the future. So just keep that in mind. Okay, so let's look at trademarks. So copyrights, think of like works of art, that type of thing. But there is crossover between trademarks and copyrights. So a trademark is a word, phrase, symbol, or design, combinations of words, phrases, symbols, or designs that identifies and distinguishes the source of goods of one party from those of others. And to find out information about trademarks and trademark law, you would go to a different website, which is the U.S. Patent and Trademark Office. So uspto.gov. You can actually there go search trademarks. It's hard to search copyrights because they're graphical, right? But a lot of times trademarks are words and phrases. So it's actually a searchable site to see who owns trademarks. Now, keep in mind that people generally cannot own words, okay? Generally cannot own. I'm not an attorney, okay? But generally they don't own those words. And you know, they use words and identify them as a trademark for a certain product or service, but that doesn't really mean that they necessarily own those words. If your last name's Davidson, you want to name your kid Harley, you can do it all day long, and Harley Davidson can't sue you. They don't own the words Harley Davidson. But if you want to build a motorcycle and name it Harley Davidson, you're going to be in trouble because they've trademarked Harley Davidson to a variety of things, including motorcycles. Okay, so you know, when we start looking at trademarks, they are a little different because sometimes it's just words and phrases. I'll give you a really interesting example. In the state of North Carolina, the University of North Carolina at Chapel Hill, referred to in our state typically as Carolina, they do not have a trademark on Carolina. But if you reproduce the word Carolina in basically baby blue, Columbia blue, then it's considered infringing on them because they basically trademarked the words Carolina in that color because that's their school color. Now, if you go to the state of South Carolina and you print the word Carolina in red, you know, now you got problems with the state of South Carolina because the University of South Carolina Gamecocks, it's red. Okay, so I mean, it's very interesting how some words carry more importance in some states than others because of how they may or may not have been trademarked. Okay, all right, so trademarks, again, used to differentiate goods and services offered by competitors. If the trademark is creative, like the Nike swoosh, as I mentioned, then it can typically be copyrighted as well as be a trademark. Now, Nike's an interesting example. They don't own the word Nike, okay? Nowhere do they own the word Nike. Nike was the ancient Greek goddess of victory. So Nike, the Greek goddess of victory, has been around a lot longer than the shoe company, right? It was also a type of anti-aircraft missile developed by the U.S. military in World War II. But they adapted the word to be used as their brand name and trademark for their line of shoes and related products. The swoosh is a trademark because it also represents the brand, but it's also copyright because it's a unique expression of an idea. Now, in theory, okay, and don't try this at home, you know, if you wanted to sell a line of toothbrushes and you wanted to trademark Nike for a line of toothbrushes, as long as they hadn't already done that, you could do it. I wouldn't dare do it, and I dare say that I know they would show up your front door and you might just lose that case. But the reality is when people trademark, they actually go to the trademark site and they start listing all the different products and services that they want to offer underneath that trademark, okay? Anything outside of that, in theory, you could do, but don't try that at home, okay? I don't think you're gonna get good results. Go talk to your attorney. But just an example of how that's been done, okay? The word Thunderbird. Ford has a trademark on the word in association with a specific model of automobile at markets under that name, and all the accessories and, you know, everything else that goes with the Ford Thunderbird car. But if you do a quick research, you'll see there's 187 records pertaining to the word Thunderbird on the government website. And it turns out there's like another company, the Red Chip Company, they registered the word Thunderbird as their trademark for a line of audio equipment. There is also an alcoholic beverage that goes under the name Thunderbird. I also know of a company that produces sound systems that uses Thunderbird as their trademark. Thunderbird Technologies Corporation has registered the word Thunderbird as their service mark in regards to designing of microelectronic devices. So you do see that other people out there may have trademarked the same words, but for different products and services. First time you try to do a car, Ford's going to come see you. Okay, so that's just how it works. So in general, as I said, no one really owns the word, but they're basically using it as a branding purpose. Okay. Now, trademarks can lose their protection over time. Sometimes it becomes so generic, it becomes a loss of protection. Okay. Aspirin. We think about it. A lot of us think of aspirin as being Tylenol, the Goodies headache powder, all these other different products, right? You have a headache, you're going to take an aspirin. That doesn't mean you actually took an aspirin, right? Aspirin is actually a brand name, but it's lost a lot of protection. The escalator, you can ride the escalator up and down. The escalator is the name of the company that created the system. But now we use it as a generic term, like same thing with thermos. Okay, you talk about I have a thermos full of hot water. I mean, hot chocolate, whatever. It was actually a brand name. Nylon, brand name. I think DuPont owns it. It doesn't mean they can't fight it, but it becomes very, very difficult to do. So there is loss of protection out there. In the world of copyrights, you can sometimes lose protection because you put too many things out there in the public domain and not really followed up on them. And after a while, they kind of lose their protection too. Just going back to copyrights for 1 second, there are things out there that you can get off the internet and use. I mean, that isn't a violation, and it's a gray area. But a lot of times, if you're using things like in school research papers and things like that, and you're pulling off images, then the copyright laws allow you to do that. But before you start doing anything for commercial purpose, you better make sure it's okay, via your attorney. It's not required that trademarks be registered. Just adopting and using a trademark in association with your goods or services will establish what they call a common law trademark. But it's good to put a TM because you're trying to tell people, yeah, I trademarked this. This is my trademark. I mean, it's like a warning. Get away, right? A TM just means that it's trademarked. It doesn't mean that it's been registered. If you see the R in the circle, then it's actually been registered. But you don't display registered if it hasn't been registered. It gets you in trouble. It's also geographical. Trademarks can be geographical. For example, and I changed the names. This is a real case here. If you were the first to open Soho Subs in New York City, you will probably be able to prevent others from opening up a Soho Subs in the same general area. Okay. But if someone else opened one in Miami, you may not be able to prevent it. So it becomes geographical in so many cases that people don't realize that as well. You can register just in your state, or you can also do a federal registration, which gives you broader based, protections. But there still may be challenges about, the geographical location, just something to keep in mind. All the information you need for actually figuring out how to do this is on that website, but you still may want to use an attorney to help you do it and do it right, if you know what I mean. So keep that part in mind. So let's look at a couple of scenarios here that will probably impact you at some point if it hasn't already. This is like firsthand experience again. All right. A local, this is true, happened to me, Chevrolet dealer wants to order shirts with the Corvette name and logo. He's an authorized dealer of the product, Corvettes. So this seems legitimate, right? I mean, the guy called me up and said, hey, we want to get some of these for our sales staff. And I'm like, okay, sure, we can do that. And in the back of my head, there was something that was just saying, check into this. There's something there that I'm not aware of. There's something I'm forgetting. So I checked into it. And what I found out was that just because he sells Chevrolet products, it doesn't give him the right as a Chevrolet dealer to reproduce specific trademarks, such as this case, Corvette, Camaro, Yukon, etc. Basically, what I learned in that situation was with most automotive dealerships, many businesses, big chain businesses, like some of the chain real estate agencies, boat dealers, whatever, that the master organization, in this case General Motors, gives them a media kit. And in the media kit, it contains the logos that can be reproduced at will to support that dealership. If you want to go beyond that, you have to get permission from headquarters, basically. And we were able to get permission in this case. I explained to the dealer, he contacted, headquarters in Detroit or whatever, and we got a letter of authorization for him to do it. He wasn't allowed to sell those shirts, but he could get them for his staff, and he was able to, hire me to do it. So, we went through it the right way and put the letter in a file, so we always had it there. So most of them don't know this limitation, to be honest. It's a surprise to them. So be careful with that one. Okay, and I found that with some of the other car dealers I've worked with. Then you find things like celebrity names, and like again, does Dale Earnhardt Jr. actually own the words? No, there's other Dale Earnhardts in the world. Okay, it's how the words are represented. If he's trademarked it in conjunction with him as a racing figure, and he's going to sell apparel and other things, merchandise under it. You can see there, for example, his signature across his car, number 88, and that's apparent. It's obvious when you see it that, unless you know nothing about racing, and not everybody does, that this is Dale Earnhardt Jr., the racer. So he is essentially trademarked, maybe even copyrighted, and licensed probably, his name and different images of it. I mean, certainly me reproducing an image of his car with the number 88 is going to get me in trouble. Okay, so we don't do that. I used to have at Christmas all the time, and it was funny. I'd have ladies come in and they'd want me to put, a racing car driver's name and number on a jacket for their husband for a Christmas present, And I said, well, I'm sorry, I can't do that. And they said, well, we'll use Dale Earnhardt as an example. My husband is Dale Earnhardt's biggest fan. I think Dale Earnhardt would love it for my husband to be wearing a jacket with his name on it. I said, he'd love it if he got his cut of it, okay, but he's not getting his cut of it doing this. And that's why you have to buy it from someone who's selling licensed, apparel that, is able to do that. If you can show me your husband's, pictured driver's license and his name is Dale Earnhardt, then I'll put it on there, but not like that. I'll put it there in block letters because that's his real name, So, yeah, you run into this kind of stuff all the time. You think it's perfectly innocent, and it's not. And the trouble is when someone decides to come after you. I mean, how many times are us working out of our garages, does anybody even know we're there, right? But you never know who's looking and who's watching. So don't fall into that trap, okay? It's out there, so just be careful. So let's talk about something called parody. Parody becomes very interesting too. How well is it protected? So let's define parody. Parody is a work created to mock, comment on, or poke fun at an original work, its subject or author or some other target, by means of humorous, satiric, or ironic imitation. And it's found in art and culture and all kinds of things. So it gets kind of crazy here because in general, parody falls under the protection of the First Amendment, freedom of speech. Okay? But there's so many variables, you could easily get sued for infringement, so you got to be careful. So let's look at some real quick. Here's a true case. I'm very familiar with this particular one. I've been to the Black Dog Tavern, which is in Martha's Vineyard. And the thing about the Black Dog is they probably make a lot more money on their logo than anything else. So if you ever see somebody wearing a gray sweatshirt and it usually has just a solid black lab on there, that one's got a little color, and the words the Black Dog, it's probably from the Black Dog Martha's Vineyard. Okay. So anyway, that's their logo. But Peter Hall was an individual who started producing parody t-shirts, including Dead Dog, with a black silhouette of the dog upside down, and Black Hog with a silhouette of a pig. Okay, so he was doing parody, or so he claimed. He claimed it was parody. And when it was all said and done, the court noted the fact that the plaintiff's sales have increased every year since it started selling t-shirts, which is just the sales parody t-shirts did not dilute or hurt the selling power of the original trademark. So remember, the plaintiff was the person who owned the Black Dog. So when he filed the lawsuit against the other guy back in 1993, when the court looked at it and said, man, your sales keep going up, this guy really didn't hurt you, so yeah, parody is fine. So he lost his case, okay? And freedom of speech went out on that one. The funniest
Yeah,
one I've
and
go ahead, David.
we're going through there's a lawsuit in our area now that just made MTV. We have a restaurant bar called Floribama, and NTV came out with their show. I think it's called Floribama Shore, and um, they filed a lawsuit over MTV using their name
Right.
in that context. So some of these things are difficult to know where the line is and what
True.
you can do. But obviously, anything that attracts that kind of attention, you want to, walk softly.
Right. Absolutely. This right here, my next example is my favorite because it's just funny, especially when you read what the judge had to say. So Nature Labs sells a number of parody fragrances for pets, including Poochie, okay, a parody on Gucci, right? Ms. Claybone, a parody on Liz Claiborne. Tommy Holdigger, which was a parody on Tommy Hilfiger. Okay, so Tommy Hilfiger filed a lawsuit saying the parody infringed on their trademark. So once it was reviewed, this is great. The judge made a point of acknowledging that the defendant's products were probably not sold in the same stores as the plaintiff's products, and therefore asserted that cologne for an animal cannot be confused with cologne for a person. Even if a dense, listen, this is quote. I want you to see my little quotation marks. I took this right out of the legal brief there. Even if a dense and humorless consumer could mistakenly conclude that the plaintiff itself sponsored the humorous line of fragrances, the court was quick to point out that Hilfiger had nothing to lose from mere association with pets. And as for the dog perfume, if you like Tommy Hilfiger, your pet will love Timmy Holdigger. The court found that a statement drawing a likeness between the buyer's own taste and that of his or her pet is unverifiable puff. Thus, the court dismissed the plaintiff's claim of advertising, false advertising, excuse me. So these are things where if you actually study cases, you can find some very interesting things back and forth. As I said, so much of this is not black and white that it has to go to court to be settled. The thing that you want to be careful of is not getting dragged into that because of the cost to you and having to defend yourself. And I go back to my very simple phrase, when in doubt, lay out, man. If you're not sure about it, ask for a letter of authorization. We found at one time that a lot of firefighters, we all love our firefighters, right? And you would see fire trucks that had, well-known cartoon characters like the Tasmanian Devil on the side of the fire truck. Well, they weren't ever authorized to use that, and several fire departments got sued by, I believe, Warner Brothers owns it. And I think what happened was there was so much public outcry about how you dare you do that to the firefighters, they kind of backed off. But I've also noticed that there's not many fire trucks anymore that have those kind of, I used to see Yosemite Sam on some of them too, anymore. And, me as someone who's coming, the fire department coming to me, I'm, hey, okay, sure, I'll do this for you. You're great people, firefighters, right? Now, today it would be, I need a letter. I need a letter from the owner of this saying that you have authorization to have it reproduced and I have authorization to do it for you. And then file that away. Even if you get sued later because they didn't have authorization, if you actually took due diligence, as we say, to attempt to protect yourself and verify that it was legitimate, that can go in your favor. So, get things written out. I think David said it in the very beginning. Get it written out and then put it aside for a future use and always save it because you never know what's going to come your way. All right. You just don't know. And for a lot of us, it comes down to sports, like school sports and whatever. And licenses, colleges are licensed. Don't let anyone try and convince you to do any, college logos without a license. Don't go anywhere near that.
Yeah, and one thing on college stuff, there is a licensing arrangement called a crafter's license that many universities offer. So Google crafter's license, even the University of Alabama has a crafter's license that you can apply with almost no red tape, almost no forms, that gives you the right to sell up to a certain dollar amount of the products, assuming these are handmade kinds of items like
Right.
sublimation. So many times you can actually do it legally without going through a lot of work.
Yep. And, I actually do have a legal license, and it was a bit of work, but it's actually legal. It's a smaller university, but still, it was easy. I didn't have to pay royalties, was a nice thing. I just have to pay annual fees. But yeah, be careful on that. Look into that. Protect yourself on that. It's not worth the trouble you could get into by just trying to take a shortcut or kind of dance around the issue. Okay, because there's so many things out there kind of waiting for you. So keep all that in mind. Well, that's pretty much my last slide there, and I know that we have some questions, so I'm going to take a look at questions, but I want everybody to keep in mind, as I've said before, I'm not an attorney, okay, and I don't practice law, and I cannot give you legal advice. Anything I would tell you is my own personal opinion, and the biggest piece of advice I can give you is talk to an attorney. I mean, just a simple consultation is not, it might be, $100, $200, whatever the hourly rate is, right? But a simple consultation can probably save you thousands of dollars of heartache. And in fact, a lot of times you can get simple consultations for free. So please do keep that in mind, because again, I know a lot of times your questions, you have a certain situation and you want to know if it's okay or not. And I'm not the person to tell you it's okay or not. Okay. So with that
I
said,
had one example, the most common example that fits under this scenario, both from a trademark and a patent, is pop socket. So many times a day, people will call us and say, can I buy the pop socket? Because they've seen it sold by other Chinese vendors. And the pop socket is a patented product. It is a trademarked product. The name is trademarked. The product itself is patented, and they do not provide a blank version of the product for you to sell. Maybe one of these days. We actually helped the people develop the product years ago. And so when you see Chinese vendors providing these products, PopSocket is going to find you, and they're going to shut you down. They're going to shut down the vendors as they bring it across our borders. And so it is foolish to play with fire like that. So, when you're in doubt, you can probably do a quick search and find out if you're breaking the law. But if you know you're breaking the law, then you probably shouldn't do it.
right. The first one I'm going to read out to you guys, because I've heard this and I've seen this before, and I think I know the answer, but again, don't make a decision based on me. The fabric sold in the stores, is it okay to use and sell without the permission of the company whose logo is on the fabric? For example, the St. Louis Cardinals or the St. Louis Blues, if that was on the fabric, can you buy that fabric and then, I don't know, customize it and resell it to somebody else, or modify it and sell it to somebody else without paying them a royalty? I wouldn't do it. I've run into cases where people bought licensed product. This was a university. They were a retailer. They bought licensed caps with the name of a university, a major university, and then they added embroidery to those caps and resold them in the store and got in trouble because they were supposed to pay an additional royalty or something like that. So I don't know the details, but when you start talking, especially bigger names like that, you do have to be very careful about selling something that has their logo on it, even if you went out and bought it and paid for it. Okay, because now you're making money off their logo. So therefore, in theoretical, they are entitled to some percentage of that. That's a great question for an attorney. As I said, I'm not one. So the same thing with your second question there. Is it legal to use a yard flag for a tote bag and sell it if it has a logo on it? Again, I don't think so. I think that because you're reselling it with someone else's logo, even though you bought it to begin with, that now that you're making money off their logo, that you're going to have to be in a position to compensate them. So my answer would be no, but as always, I'll talk to an attorney. Your opinion of Google image labeled for reuse, I don't trust anything like that, okay? Labeled for reuse, what does that mean? What kind of use? Typically, if someone's providing something for you in that way that, you know, you could download and reuse this or whatever else, they are spelling it out somewhere. They actually have a whole legal little block that you know, tells you what you can and can't do with it. So I would dig a whole lot deeper and figure out what does label for reuse mean, okay? That one's a little tricky, but look into that one deeper. And then always be careful if it's a website you don't know who they are. They're a little bit, I don't know. You don't know who they are or where they're coming from or anything like that. You got to be careful because a lot of times people will put stuff up there just to get you to their website, and they're putting products up that they don't have the right for you to use. Okay, just one of the things to be really careful of out there. Let's see. This is something I didn't bring up, but it's a great question. Hi, can a high school license, their, okay, wait a minute. Their grammar was a little bumpy, which happens all the time on chat. So let me just paraphrase it. Basically, they're asking about high schools having licensed mascots and stuff. I would say that in general, most don't. But that doesn't mean they don't. Okay. I know a lot of the private schools have, you know, gone and put together licensing for their products, just because that generates more income for the school. And I've always wondered why our public schools, at least where I live, have not gotten around to that. In fact, our public schools got into some trouble, almost everyone in North Carolina, because so many of them were using mascots who were actually college mascots. And the colleges, and one of the things is you have to protect. You have to protect your artwork, your IP. If you don't protect it, it loses protection. So the courts look at people that have IP out there, that if you're not routinely going after everybody that infringes you, everybody that infringes on you, then you're being selective, and then maybe, you know, you don't have protection anymore. So there was a big crackdown on our public school system because it turns out most of them were using the same logos as by the major universities here in the States. So they'd all go and change their logos. So, you know, I'm not seeing a lot of high school license program, but that doesn't mean there isn't one. Okay. So it's one of those things that you just have to ask the administration, you know, of either the school system or the individual school. If they have a program, they know it. And if they don't have a program, then they probably don't even know what it means. What about students in the high school doing one-off projects such as learning experience? Again, in most high schools, I say most, in many high schools, there is no licensing to be a problem. Also, if there was a license, okay, then the school itself is like the owner of the license. So the school can dictate how it's used. So the school can say, yeah, students can do this all day long in a school store or a graphics class or whatever else, because it's their license, it's their IP. So that's, you know, and I don't think any of them would hold them back. I mean, I even see that in colleges where, you know, in big name colleges that make a lot of money on their IP, their mascots and stuff. Yeah, they you know, within the students' body and everything else, sure, they're able to reproduce things as part of their, you know, classes and things like that. So probably okay with that for the students anyway.
You still there, Jimmy?
Yeah, I'm still here. I'm sorry, I was reading one. It was kind of long and very interesting. So just give me 1 minute here, David. They wrote a nice long book, but it was very interesting. And boy, I do not have the answer to this one. Again, this is another great example of talking to an attorney. Okay, but I'm going to read it, all you guys out there. All right, so just pay attention. My son took a photo of a graphic design on a wall in what's called Graffiti Alley in Canada. I altered the design, removing the background, and sublimated the result on a t-shirt for him. We've talked about and have tried looking up the artist to get permission to put on t-shirts and sell. What may be our options if we're unable to make contact with the artist? Would it be an infringement of copyright to reproduce and sell? You know, as I've said but so many times today, I cannot tell you whether that would be or not. But my greatest fear if I did that is that even though I try to find the artist, he suddenly pops up about 15 years from now and comes after me for everything I've done. So this is one of those things where I would go back and talk to an attorney. Again, it doesn't take a lot of money to go have a talk with an attorney, especially something as specific as that. Any idea if the USPTO, that's the U.S. Patent and Trademark Office, if the website says their trademark is dead, expired, or if it's okay to use? It seems like, I haven't looked for that information, to be honest. It seems like I've read before where something is, I don't want to say it's okay to use, but I like the terms dead or expired. It's kind of like, so you have to renew periodically, and it's been renewed. And so I don't know that that means it's okay to use, but it's something to ask an attorney on that. But I haven't seen where it clearly states anything that says, oh, this one has expired and is okay to use. I'm not sure about expiration either on trademarks. We know it's 70 years after death of the author for a copyright, but I don't think it spells that out on a trademark, because a trademark is considered something that would go on forever because it's company related, whereas a copyright typically is person related and they're going to pass away eventually. Does it matter if the customer uploads their own image? And I'm not sure what you mean, uploads their own image to where? I mean, to you? I mean, obviously, if the customer is providing you with an image, if you have any doubts, if that image, if a customer brings an image to you that they don't have the rights to use and you reproduce it for them, if they get caught, they're in trouble and so are you. Okay, they're most likely going to come after you too. All right, because typically in the world of lawsuits, you go after everybody involved in any way. That's just the way it is. So just because the customer gives you an image to reproduce doesn't mean they have permission. We would hope they do, you know, and I haven't gotten in much. I've been doing this for 30 years. I only have one cease and desist. That's not too bad, I guess. But again, you may have a policy of having somebody sign something every time that they bring you in something to reproduce, saying that they have permission for that, they own it or have the rights to it or a license to reproduce it or something to that effect, that, you know, you have them sign, and then you keep that on file, because then if somebody does come to you and say, hey, you did this, and say, absolutely, here's the letter this guy gave me, you know, and if it's something you know, it's Coca-Cola or somebody like that, right, you want to make sure that there's a letterhead from Coca-Cola, you know, on that. What if I trace an image from Shutterstock and change some aspects of the art or recolor? Is it mine now? Not really. If I just trace an image, is that mine now? You know what? It's a gray area again, because I'm kind of understanding what you're saying. You're saying you didn't reproduce like every detail, you just traced something out. But be very careful. I mean, it's amazing some of the things I've seen that people have sued and won on that were very, very, very simplistic. So you do have to be careful about, taking anything and changing it, because just because you change something doesn't mean that it's not a copyright infringement, because you had to start with the original to be able to change it. Um, this is a good question I hear all the time, and I'm going to tell you the same thing. See, I'm protecting myself. I keep telling everybody to talk to a lawyer, but if you take a picture of something like, say, the castle at Disney, can you use it, or is it protected? When you take a picture, you own a copyright in the picture. So if you took a picture of Cinderella's castle and in Disney, and then you put it on postcards or something, Could you sell the postcards without having permission from Disney? I think actually the answer is yes, but don't quote me on that. But you do have to be careful, because if you turn around and start creating products that would appear to be Disney products, then you're crossing a path, you're crossing a line. And Disney's a big, big player. Okay, so that means that um, they're not somebody you want to deal with.
I think again, this is where an attorney would guide you, but I think the answer is you can't do that, because you're diluting the Disney, um, um, I guess the Disney image, if you will, and making money off of it, and I don't think you're allowed to do that. Um, but again, it's one of those things that you should seek a competent opinion on. Um, but I think there is a problem, is because you're setting yourself up to be Disney, if you will,
Right.
by selling Disney products. Now, there's a very famous legal case in Alabama where an artist painted a picture of a famous football scene in the University of Alabama. And so it was a painting, wasn't a photograph. And they got into a legal dispute, and I think ultimately the university lost
Right.
in that particular case. But again, that's I'm not sure, but I don't think you can just take something, you know.
Like wholesale, yeah, exactly. If it's like someone comes to you and they took a picture of their family in front of the castle and they wanted to have that put on shirts, I don't think there's any problem at all with that, because it's really about the family. And let's also face it, you couldn't sell it to anybody else but the family, right? So I think you'll be okay on that, but you do have to be careful. If you just had the castle only, you're implying it's a Disney product, and that's where you would get into trouble. Um, I've heard that, well, another person who takes the picture has a copyright in the photo itself. I do know that. But you might be crossing the lines on trademarks in when you start trying to reproduce and sell that photograph. It's yours to reproduce for you, but then if you try and take it to another level, maybe not. So, as Dave said, attorney's way to go. Yeah, I like the next comment. It's great. Okay, thanks, Joy. So what's left to embroider or sublimate on? Listen, all we're saying here is don't feel like we're closing out the world to you. Well, what we're trying to do is say, make sure you do it the right way. That's the thing. If you want to do colleges, go out and get a license to do colleges, and then you'll appreciate the license, because that means anybody that does it without a license, you can turn them in and they get shut down. Okay, it's educate yourself, and and then go out there. I mean, you're going to, all day long in your career, you're probably going to reproduce logos. I mean, you can be just fine in images, and you can be just fine. But it's those, all you need is one bad experience, and that's just, take the time to protect yourself. That's my whole point. I'll tell you what, your questions are coming in faster than I can answer. So I like the one that comes from Renee. So it sounds like to me, if I intend to be serious about this business, I should get a lawyer. Absolutely. I mean, at least have one that you can talk to. Um, and yeah, and your second part, and what about protection? What protection does an LLC provide me? Really kind of depends on who you're up against. Okay, I hate to tell you, but you would have to go read the law on that as well. So there's lots of different things that are going to come up in your career, legal wise. Um, Consult the right people. And a lot of times it's nothing but one conversation and you get it figured out and you keep on going. But always remember the other side. When you're creating your own stuff, watch out for the people that take it. And that's when you really start to understand the pain, is when you created something and you put it online, or to sell as a product, and other people knock it off. Okay, meaning they steal it and start reproducing it. Then you realize that they're taking money out of your pocket. And that's when you really understand the power and why copyrights and trademarks are so important. And like I said, been there, done that. So anyway, okay. Oh, I'm sorry. Just a very scary webinar. No, it's not a scary webinar. Okay. It's about getting educated. That's all it is. So anyway, I'm sorry that I can't get to everybody's questions. She has lots of great questions, but most of these could be answered by an attorney correctly and quickly. And, just keep that in mind. We've said that all day. We want to say it one more time. Do that. Okay. But if you're in doubt, like you see on the screen, my last piece of advice, lay out. Okay. All right, David, I think that's it.
Well, Jimmy, as always, thank you, and we look forward to getting back together again, and appreciate everybody being part of this. Till next time, you take
Absolutely.
care.
You too. We'll see you
Thanks.
next time.
Bye-bye.